Um, I'm not sure I would say congratulations to you because this will be a very major case that you have lost in the court. You have served notice that you are going to appeal, but the question would be to what end? And Sami Jemfi has just summarized, saying that the Court of Appeal has said there's no case against their friend, their member, so it's a pointless decision for you to proceed further. Kindly share with us why you think this is not over.
I think that first and foremost, it's important to recognize that the Court of Appeal itself was even split in the determination of the question, whether the accused persons had a case to answer. So even though the Court of Appeal itself, they were not clear, or there was no unanimity among them. So clearly the Court of Appeal itself, one of them had a contrary view. And that is actually not the only reason why the decision ought to be appealed against. The decision ought to be appealed against because, for me, it is perverse. It goes contrary to all the established authorities on causing financial loss, and also flies in the face of the solid evidence that was led by the prosecution at the trial. And what evidence am I talking about? I'm talking about, one, the establishment of all the ingredients of causing financial loss. So, one, the establishment of causing financial loss, that the financial loss had been caused in the matter. Two, the establishment of a link between the accused persons and the offense with which they were charged. So the financial loss clearly was established in this manner. Vehicles were imported into the country in December 2014, and the vehicles were supposed to be ambulances. When the vehicles arrived, they were devoid of any equipment that would render them unfit for use as ambulance. Apart from that, the vehicles were even contrary to specifications agreed in the contract. The vehicles were also, to show the criminal intention of the accused persons, imported outside the time frame agreed under the contract. So by the time the contract was being performed, the contract had even lapsed, because the contract was signed in December 2012. If you look at the timelines for the performance of the contract, they had 11 months within which to perform the contract. That would take us to when? It's not December 2013. So, and by that time, not even a single ambulance had been imported. By August 2014, when the then Deputy Minister for Finance, Ato Forson, was writing for the LC to be established and for the vehicles to be imported, the contract had been lapsed. Apart from that, it was even without a request by the Minister of Health, which was supposed to use the ambulances, because the Minister for Health then, Madam Shariati, had explicitly written to the company, Big C, for them to stop production of the ambulances, because the Minister of Health did not have any money to establish the LCs. And somehow, without any request at all by any person, without any authorization, Dr. Ato Forson then wrote for the payment for the vehicles. The letters were written on 7th and 12th August 2014. After that, the LCs were established on 18th August 2014. After that, the ambulances were then shipped from Dubai and then arrived in Ghana in December 2014. And it will interest you to note that throughout the remainder of the term of the SOR Mahama administration, they failed to convert the vehicles into ambulances. And that is because, clearly on account of the evidence returned at the trial, which consisted of reports by the Ministry of Health and the National Ambulance Services, the vehicles could not be used for the purpose. They could not be converted into ambulances. Indeed, the Ministry of Health commissioned the authorized dealers of the ambulances, commissioned the authorized dealers of Mercedes-Benz, which supplied or from which the ambulances, the vehicles were procured, to assess the vehicles. And they made a determination in their report that the vehicles were not fit to be converted into ambulances. And that's because they were contrary to specifications agreed under the contract. It was not just a case where medical equipment had not been fixed into the vehicles, and for that matter, all it required was for the medical equipment to be fixed into the ambulances. Indeed, almost every material part of the vehicles was defective. from the body to the engine to the interior parts and all that. They were contrary to the specifications under the agreement. So clearly, if vehicles have been imported into the country rather than ambulances, and those vehicles cannot be converted into ambulances, they cannot really doubt that the financial loss have been caused. And it is not I, Godfred Dame, saying so. In the words of the former Minister for Finance, Dr. Alessebifia, in 2 letters that...
Former Minister for Health.
Yes, former Minister for Health, I'm sorry. Dr. Alessebifia. In 2 letters that he himself had written, the vehicles were ordinary vans, which could not be used for the purpose for which they were procured. So that is clearly established.
Okay.
And now the link between the accused persons and the offense is so clear. Without the act of Mr. Ato Forson, which consisted of authorizing payment for the vehicles would not have been imported in the first place. And it was not even pursuant to a request by the Ministry of Health, as I've indicated. If my ministry requires some vehicles to be procured and whatever, I will write with all respect to the Minister for Finance, attaching evidence of the exhaustion of the procurement process and all. And it is a duty of the Minister for Finance to inquire whether indeed there is basis for the payments to be carried out. In this case, without any authorization whatsoever, the Deputy Minister of Finance on his own wrote for the establishment of the letter of credit. And it's not just a matter of establishing LCs, and it is not also, as with all respect, as light as some people would want the public to believe that LCs are just a guarantee for payment. The LCs themselves were the means of payment agreed under the contract. Indeed, if you look at the agreement, clause 4 of the agreement, it says the vehicles shall be paid for through the establishment of letter of credit, a revocable letter of credit opened in favor of the sellers. And that's exactly what was done in this deal, pursuant to the authorization of the then Deputy Minister of Finance, Ato Forson. Then, of course, the role played by Japan is quite clear. He is the one who introduced the company Big C to the public officers in question at that time. Without Japan's introduction, the government of Ghana would not even have gotten to know Big C. Apart from that, he profited several €700,000 out of the 2.3 million euros that was paid under the transaction.
Okay.
And what kind of transaction is that? That you pay for vehicles worth 2.3 million euros, and then an agent, a middleman himself, profits from it as in the quantum as much as 700,000 euros. I'm not surprised that they're not able to supply the vehicles or the ambulances that we're supposed to supply.
Mr. Attorney General, the bigger question would be that all the issues we've raised notwithstanding, the Benz buses have been brought into the country. That's one, over a decade ago, if not close to a decade ago. The items that are needed to be fitted in them to complete them as ambulances, as the opposition party has claimed when it was in government at the time, have been imported. The government that you are a member of cleared these items at the port, which is intended to be fitted into these vehicles to make them complete ambulances. As we speak, these buses, we are told, have not been fitted with these items to make them full ambulances. Let me land with a question that you can respond. What? So the question is, if these buses are in the country and they have not been fitted with these items that your government has imported, you on the other side are causing a financial loss to the state as well as a parallel. You are guilty of the same thing you are accusing the previous government of doing.
I think no, I will not. That's why you see. I think that it's a very gross misrepresentation of the facts. Apart from that, it is it just plays the gallery, because I've already told you that the vehicles were imported in December 2014. The material question you ought to ask yourself as a radio presenter, a person hosting such an important program, is how come from December 2014 up to January 2017, the vehicles could not be converted into ambulances? Or how come the equipment that had allegedly been imported could not be fitted?
They said the equipment were imported in your government in 2017.
The government took possession of the vehicles in December 2014, in December by 2015, the vehicles had actually been moved to another location to forecourt to the State House. And indeed, they had actually also been to Dubai to carry out inspection and had agreed on, had prepared a report that they presented to the government of Ghana. And I'm saying that...
When did the accessories come?
The simple answer... Are you listening?
Yeah, I'm listening, but yes. You see, they said that the accessories came in 2017. Is that true or false?
No, it is false. It is false. That is contrary to the evidence on record. So I think the first is false. I'm saying that apart from that, there's a report by the authorized dealers in Mercedes-Benz received by the SOR Mahama administration in 2015, which was tendered in evidence at the trial. It is part of the exhibits at the trial, which showed that the vehicles could not be converted into ambulances. Clearly, and that's the reason why the vehicles could never be converted, or the equipment could not be fitted, because indeed the wrong specification of vehicles were supplied to start with. A contract is entered into between the government of Ghana and another company, and it is specified that you should supply Ghana government with Mercedes-Benz A309. And then you on your own, without the authorization of the government of Ghana, supplies Mercedes-Benz A311. And then you subsequently say in court that, oh, that is even bigger and better. So that specification cannot be converted into an ambulance. And then you say that subsequently you imported some equipment into the country, and therefore somebody should bear the responsibility of converting it into an ambulance. Well, indeed, he had the opportunity of actually carrying out the exercise for over 2 years before he left office, and he couldn't do so. And I'm saying that's because of this report, which was commissioned by the Ministry of Health and the National Ambulance Service. And it was not a report commissioned by the Godfred Dame administration. It was a report commissioned by the SOR Mahama administration and tendered in evidence at the trial. So I think the question, Maru, with all respect, you have to ask the people who are founding that theory is, what do they say about that report?
Very well.
How can the vehicles not be converted into ambulance?
So I think that one final question. Okay.
Yes.
Just one final question.
In a case where, for me, this case really highlights a lot of impunity in public service. We are in public service. We're supposed to safeguard the use of the public purse. We're supposed to ensure that our acts are careful and not reckless. And that's the essence of all these financial loss cases. If you look at the financial loss cases, the ingredients of all the offenses is that really a public officer, contrary to the mandate that he seized with, carried out an act which was reckless and was without regard to due reason and caution.
Okay.
And so if once you establish that, then the offense has been committed. And that is why I think that this decision by the Court for Appeal is most unfair and absurd, and indeed must not stand.
Okay. So until it is overturned, it remains what the situation is. Now, I remember also that there was talk about Big C trying to pay back some monies to the state so that we do not have to even proceed with it at all. On the criminal side of things, the best you can secure is a jail term for the accused persons. Big C was going to give us money. With hindsight on your side now, would you say you should have taken that money and ended the prosecution so that the state gets money, these people walk free?
First, it is not correct that all the state can get in this matter is a conviction or a jail. No. The court can, either in substitution of a jail term or together with a jail term, order the payment of the sum which has been lost in the matter. And the courts of Ghana have done that in numerous cases. This is the very first case in which the court would have had the opportunity of ordering the payment or refund of the amount in question. So the process that we're backing on clearly, was one that was not inconsistent, or was not inconsistent with a recovery of the money. Secondly, it's also important to note that the manner in which the plea bargaining offer was made itself made it unacceptable. The manner in which it came really rendered it unacceptable, because it was made by a party which was no party to the proceedings in Ghana. It was an offer purportedly emanating from BC. BC is not a party to the proceedings in Ghana, had never come to Ghana to acknowledge any liability in the courts of Ghana. Now, if BC had defaulted on paying the amount of money, which of course we know that they are always likely to default. Even in kind of the terms of the contract itself, there was a lot of default. How was I going to hold any of the accused persons responsible? And how would this sound? How reasonable would it sound that I, as the Attorney General, and I take to terminate prosecution on account of representation made by a party who is no party to the proceedings in question? I mean, so clearly, that offer itself was unacceptable. And indeed, when I inquired from the accused persons on whether by that, to say the first accused, so the offer by BC came through the third accused, which is Japa. And then subsequently, the first accused brought a letter purporting to associate himself with the terms of the offer made by the third accused. And he actually stated that he was not opposed to the offer. I found that a little bit ambiguous. So rightly, our office inquired from the first accused whether by that he should be understood as also coming under the plea bargaining act. The first accused said no, he was not doing so. So you see that this whole talk about plea bargaining itself, well, for me, a charade. It was a charade because the accused persons wanted to essentially accept liability, but they didn't want to openly accept liability. And as the Attorney General, if I had accepted that today, the media people would have also been here questioning my integrity. They would have made all sorts of imputations that are taking some money from a company which is not a party to the proceedings and alternative proceedings, and then subsequently that company did not pay the money. And where would you have left me? So I think that it is important for due process to be followed.
Okay.
This is not the first time that I have been, or I have suffered a setback in my prosecution of cases. Remember the opening cases, there were two setbacks. First was a ruling by the Supreme Court of Ghana regarding a submission of no case, the same submission of no case issue. When the submission of no case of Justice of Dr. Opuni was overruled by the High Court, they filed an application to quash that ruling in the Supreme Court. And strangely, the Supreme Court, by a 3-2 decision, allowed it. Subsequently, I had to go on review, and in all humility, I succeeded, and the prosecution continued. When the prosecution continued, the new trial judge then ordered that we commence the trial de novo, which is that we should start afresh. Again, I was aggrieved, and I had to go all the way to Court of Appeal for a reversal of the decision.
Okay.
The Court of Appeal is allowed it. So this is the first time there has been a setback.
Very well.
I believe that, yes, due process will be followed. The next day or two, we'll file our appeal.
Okay.
And when the appeal is lodged, I'm sure it will be heard, and then the trial can proceed.
Thank you so much for speaking to us, sir.
Right. Thank you very much.
That's Attorney General and Minister for Justice Godfred Dame.